personalities from various fields who have contributed to the society immensely. Today we have with us a very special guest who is a well-known human rights defender in India. Advocate K.P. Mohammed Shareef is the Vice Chairperson of National Confederation of Human Rights Organizations in India, that's NCHRO. And he is a practicing lawyer for the last 3 decades, appearing in various courts of India. He had played a very vital role in various human rights cases in India and also have contributed in coordinating and assisting aspiring human rights defenders and lawyers in various courts. Today we have Advocate Shareef with us to give us insight to various aspects and perspectives of human rights issues pertaining to India and the nation as a whole. Advocate Shareef Saab, welcome to this program of Alternate Voice by Inside Media. Can you tell us about your journey in as a human rights defender and how you started with it?
Definitely I can divulge what all things or what is the track record in my profession. I started my career enrolled as an advocate 14th January 1984, and I started my practice in Kerala, Calicut in Kerala, and ever since I am this profession. During that period 1984 to 1989, I was purely confined with profession alone, and I got a tilt when I shifted my practice to Malappuram district, when I could contact some organization, members of some organization. They were started working in these sort of activities. So that made me to do something for the community, and I can, with the aid of those, backing of those organizations, I got some light in the way of doing some work towards human rights.
Shareef Saab, India is one of the largest democracies in the world. But human rights records, the track record in the human rights area, according to various agencies, it is not very satisfactory. What do you think is the reason behind this contradiction? What could be that?
So, as regards Constitution is concerned, it is very, we can say that it is a holy book. But when we come to the side of the implementation, diametrically opposed the things are seen. I know, so that the defect is on the code or defect is not on the Constitution, but we can visualize the things all along done. It is the defect is on the implementation side. That ever so many, a plethora of examples can be cited with respect to these implementation. When we take one example, that sovereignty of the nation, and when we take an example of security of the nation, a socialistic side of the core, or rather, when we secular fabric of this, when we take secular fabric of this society, and democracy even, whether it is the intention of the Constitution has been complied with or not. When we analyze those things, we can conclude that practically these highly, what I can say, that it is the terminology contained in the Constitution that can only be stated that it is only a terminology, not being executed.
You mean to say the system framework is fine, but the delivery mechanism is having the problem?
That is not only delivery mechanism, there is even the persons who are spearheading the social civil society is not having any vision at all. They don't have the audacity to implement things as contained in the Constitution. We are just talking about the human rights defense, and we are analyzing the present scenario, etc. But this, when we just analyze the provisions in this Constitution, especially the fundamental rights, the directive principles, it can be seen that the Constitution postulates, or rather the Constitution mandates, safeguard to the citizens as a whole. But on the practical side, safeguards are not being practiced in India. Article 14 of the Constitution, which reveals there must be equality before law. But do you think that provision has been properly adopted here in India? A patent apparent discrimination is visible when we sort out many instances. Likewise, there is special provision has been incorporated in the Constitution for the socially and educationally backward classes, and adequate representation also provided for those socially and educationally backward classes. But do you feel those provisions are implemented by the state? Likewise, in Article 21, we can say that is the very vital article in the Constitution that deals with the life and liberty of a citizen. Life and liberty of a citizen. What is the fate of that Article 21? We can say that that provision is only an obtuse, so far not been properly implemented here.
Shareef, about the same point where you stopped. Post 1992, we have observed large number of innocent Muslim youths incarcerated in various court cases, mostly fabricated, and whatever was taken for trial was rejected by the courts. Can we say there is an imminent bias in the system?
Surely there is bias, but before that you should just understand that there is a concept of war on terror. I would say that this bias and arrest and relentless conduct towards innocent youth is only because of, or part and parcel of this war on terror topic. The international agenda of war on terror is also part and parcel of globalization, privatization and liberalization policy of the American, Israel and other lobbies. They wanted to identify the certain rich minerals, and so that these American and other European countries rushed to India also, and they identify certain areas. And definitely when they come to India, there will be resistance group. A resistance group in the sense that they are just wanted to take rich minerals, resources, wherein some communities are finding out their livelihood. So that those persons will definitely resist when there will be relentless exploitation of rich minerals. In order to resist these sort of trials and tribulations, what these colonial forces, neo-colonial forces, done, that they manipulated, manage, and they are also hand in glove with these political bigwigs. And for the purpose of to have the vested interest of those groups, there will be legislation. They legislate new laws. They will adopt a new policy to stop these innocent inhabitants of the area. Actually, this is going on here after 90s, and that is the very reason for the large-scale wholesale arrest of innocent youth from Muslim communities, incarceration of tribals, Adivasis, other marginalized sections of the society.
Being an experienced lawyer, what's your advice to the Muslim community when being handled like this, using this cooked up stories and other things like that?
Actually, the advice should be to the society at large, not only to the Muslim community. Even other society, they should come forward. They should be in forefront to check, to curb this sort of menace. Otherwise, it will be continued. And usually, this is not only the part of globalization, privatization, and liberalization policy. And they are hand in glove with fascist forces in India. These neo-colonial forces is hand in glove with fascist forces. That is very, very detrimental to the social fabric of the nation. And this is very, very disastrous to the society as a whole. And you see, even the development of the nation will be at stake because of the sinister design of these groups. You see, a Katrina or a bunch of riots in post-independence India will reveal that where India stands now. Now the position is very, very far behind. India's position is far behind because of the aggression of these Western forces. And those persons are again to India on a new drama, and they are having nexus with, unholy nexus with a fascist group. And you see now these Gujarat and other states started SEZs, special economic zones. What is the reason for having such SEZs? And a special law will be there. There will not be any obstacle or impediment to exploit the resources from there. And now that has not been stalled there. Now you see in Gujarat there is SER, special economic regions. Special economic regions. So that this is again and again this whatever recurred to the Western forces are taken away from our nation. So that it is high time for an interference by the nation at large, and not only the Muslim community, even the other communities as a whole. Not discrimination, that upper caste or lower caste, because this is for the welfare of the nation. This is for the harmony of the nation. This is for the development of the nation. Otherwise, we cannot, we won't get chance or opportunity to build up the nation. Because definitely this Muslim community must come forward, because they are not at all realized the detriments to the society, because they are the one of the targeted group. They do hard work, they do hard work, earn something, and whenever they go up, there will be a riot, and the entire wealth will be looted or it will be destroyed. This is the history of our nation. You see what happened in Meerut, Malyana, Moradabad, Murshidabad, Jamshedpur, Nelli, Kokrajhar, and several. You cannot just set aside any place in India. Riots after riots, and when you go back, go after the riots, you cannot. For what purpose this has happened? And I cannot even say that this is a riot. These are all unilateral massacre.
We see black laws like UAPA, ASTA, and other laws like that being imposed and misused against minorities and tribals by the security agencies. What kind of impact this could have on the nation on a large scale?
This Unlawful Activities Prevention Act and Armed Forces Special Powers Act, those black laws actually lead to a heavy catastrophe to the nation. Because this Unlawful Activities Prevention Act, UAPA, is a draconian law. This can only for the purpose of nabbing these the persons who are against the imperialistic policies and imperialistic agenda. I've already stated about the globalization, privatization, liberalization, and the imperialistic hidden agenda. And as a part of that agenda, this UAPA Amendment Act has been invoked here. You see that after the alleged Twin Tower blast attack, immediately after that, there was an amendment to this Unlawful Activities Prevention Act. Likewise, within few days of the Mumbai attack, Unlawful Activities Prevention Act has been amended. And this is actually a reproduction of Tada and Pota. And this impact of Tada on the society, the impact of Pota on the nation has already been discussed a lot by the nation at large, and eventually that is culminated in the repeal. Now the very same provisions were with drastic amendment and much more grave provisions were incorporated in Unlawful Activities Prevention Act. And because of this Unlawful Activities Prevention Act, several innocent youths, they are languishing in different jails in India. Unless and until this Unlawful Activities Prevention Act is repealed, these youths, innocent Muslim youths, innocent tribals, innocent Adivasis, they will not be come out from that prison, because graver provisions are there. Bail provision is very stringent. Actually, this Unlawful Activities Prevention Act, Amendment Act, is an alien law, a foreign law, we can say. because it has been invoked here as part of the UN Security Council Resolution 1373. And as a part of that resolution, this has been placed before the Parliament and unanimously passed this amendment. Unanimously, no single party opposed this legislation. Yes, CPM has not resisted, CPI not resisted, Trinamool not resisted, Congress party not resisted. No party opposed this resolving this Amendment Act, Unlawful Activities Prevention Act. They did not even care about the stringent provisions in it. This is actually against the fundamental rights of the Constitution. This ought not to have been there. This is against Article 21 of the nation, of the Constitution. It is against the, when we go through the entire provisions in the fundamental right, it is this Unlawful Activities Prevention Act against the fundamental rights. The concept of bail is that bail is the rule and jail is the exception. When this Unlawful Activities Prevention Act invoked here, now this bail is an exception and the jail is the rule. That is the reason why this innocent youth, hailing from Muslim community, hailing from marginalized societies, that is Adivasis, Dalits, etc., they are languishing in different jails in India only because of the stringent provisions contained in this Unlawful Activities Prevention Act. You see, what is the provisions with respect to this Unlawful Activities Prevention Act on bail? Mere perusal of the records furnished by the investigating agency before the judiciary, the court believes, the court feels that there is a prima facie case, then bail shall not be granted. That is the wording incorporated in this Unlawful Activities Prevention Act. That provision, do you think that this police will place the records stating that this person has not committed any offence? Do you think that this police will give a good certificate when a person was arrested? So mere placement of the case diary statement before a court will tantamount, or rather it will culminate in rejection or dismissal of bail forever for an individual. And likewise, this usually even the trial provisions. It will be in camera proceedings. You need not disclose the details of the witnesses. There can even be secret witnesses. And this trial can be commenced any place in India. It can even inside the jail. So that these provisions are very, very draconic. And not only that, you see, when we go through the arrest provision, if a police officer, he feels some persons are assembled there, there is possibility of a terror attack. Such a belief is enough to nab the person and take them into custody. So that these provisions are highly reprehensible, and it should be thrown to the thin air. Otherwise, it will be a very, very threat to the national fabric or social fabric of the society. I will furnish certain examples of some individuals who are incarcerated for a pretty long period. That from last, that is from 2008 onwards, Yahya community, Yahya Yash community is in jail, Hubli jail, Karnataka jail. Likewise, Shibili Shardoli and Zarna Devi, they are also hailing from Kerala, is lodged in Sabarmati jail in Gujarat from 2008 onwards. And when we just scrutinize the allegations against those persons, it is very pathetic story will be revealed from it. Because this Yash Kamalkutti was arrested in connection with a conspiracy. According to them, he conspired with some other person to damage the very big installations in different places of India. And their case is that he has conspired from Karnataka one Pirgani Durga, and also from in front of a central bus station. I myself went there and I visited. There was a TV report. There was a story about him in newspapers as well, wherein it has been narrated that they conspired, Yash Kamalkutti and others were sat or rather conspired from a forest, and wherein a dargah is situated, and wherein a Pakistan flag also is there. I myself went there and visited the premises, and I could identify a dargah there, but it was not a forest at all, and there was no Pakistan flag there. And this dargah also, you see, no two persons can sit together. Such a congested atmosphere is there. Not only that, there were inhabitants very close to that dargah. In the vicinity, there were a number of occupants are there. And according to police officials, investigating agencies, they conspired from the dargah. It is highly reprehensible. It is highly improbable one. So that these sort of stories were woven by the investigating agencies, and these persons were nabbed, and the pretty long period they were incarcerated. In the very same position, very same story can also be revealed from this Ansar Nadvi, Shibili Shaduli, etc. They were in a meeting in Indore, according to the police, and they were nabbed from that Indore, Madhya Pradesh. But they were also booked in a case wherein crime has been committed in Gujarat. Gujarat, there was two incidents happened. That is the bomb planting case and the bomb blasting case. There were two incidents happened in Gujarat, Ahmedabad and Surat. There was a bomb explosion, and there was some recovery of bombs from trees. And these two incidents were happened while this Shibili, Sharduli and Ansar Nadvi were inside the jail. Even then, those persons were booked in the Gujarat incident. Similarly, so that number of cases can be cited on the same footing. And you see that the misuse of Unlawful Activities Prevention Act is easily desirable from, or rather discernible from, this booking of case in that professor assault case. There is it is known as Muatura case, and in Narath case. These two cases are from Kerala, and Manoj murder case. This is also from Kerala. These portions were misused patently because the purpose of the legislation, purpose of Unlawful Activities Prevention Act is to curb the menace of the terror activities. But when we peruse the case records of this professor assault case and the Manoj murder case and Narath case, these are purely different from this Unlawful Activities Prevention Act. This can be booked only under ordinary law, Indian Penal Code, because professor assault case is an attack on a professor. Muatumura case is an attack on a professor because he has prepared a blasphemous question paper, again that is against the Prophet Muhammad. So that is, it was because of sudden provocation, certain persons targeted the professor and attacked on him. So this is a personal dispute, and this can never be under the ambit of UAP, unlawful activities prevention act. Likewise, Manoj murder case, he is a RSS man, was killed, alleged to be the CPM carers. That also a political clash, and this can never be come under the ambit of unlawful activities prevention act. Likewise, no incident happened, even according to prosecution on Narat case. No terror activity has not been brought out. Even then, that has been booked under unlawful activities prevention. So these are all three examples to be highlighted for the misuse of unlawful activities prevention.
Okay, Shareef sir, finally coming to the last question. What is your advice to aspiring young lawyers coming to this field?
The lawyer's profession is a noble profession, and there should be a practicing lawyer, SING, not practicing alone, CANG, because they should keep up this nobility, and they should have boldness, courage to cope up with the mandates of the Constitution. Constitution provides the safeguards to the citizen, and even there is a tendency among the lawyers that when an incident happened, one untoward incident happened, and it has been termed as terror-linked case, then there will be biased attitude from not only from the lawyer side, even other organs of the Constitution. In such situation, these lawyers, young entrants, have got a pivotal role, because there will be a threat from every nook and corner. Even lawyers were killed, because you might have been heard about Shahid Azmi and Advocate Naushad Kazmi, and you might have been heard about that the setting ablaze of the office of Ismail Jaliga and throwing that black oil to one Shuaib advocate, because they ended appearance to these set of cases, so that there were threat, and there will be a very challenge to those type of lawyers. So you should not be subdued to those sort of atrocities or those sort of challenges. You should be bold, you should be courage. And I will cite one example, and you don't worry about also, because this is a constitutional guarantee, Article 22 of the Constitution, which postulates that every citizen, every person has got a right to defend by a lawyer. And Section 303 of Criminal Procedure Code also mandates so. So you are backed by, you are supported by the Constitution and the Criminal Procedure Code. So you must have the audacity to defend such cases, because this is only because of the brainstorm exercise of the media, TV, and so on. Because they will thrust upon the citizen's brain that these persons are doing havoc, or these persons are linked with terror activities, etc. Those stories may be correct, may not be correct. But you have got a right to defend in such cases. I will give one example. Even the lawyers passed resolution that you should not appear in such cases. In Fahad matter, you may be heard about Fahad's case. He was also booked under this case. Yes, he was arrested. He was arrested from Mysore while he was moving. He was riding a moped, hero push. And according to police version, he was keeping in his hand that AK-47 rifle, satellite phone, and so on. And he was arrested. But there was a version by Suvarna, a non-Muslim lady. She has stated that he was arrested much earlier. not as conducted by the police. So this is the story Latin. In this case also, this first case also, the Mysore Bar Association passed a resolution that no lawyer shall appear for this Fahad. But this matter was brought to my attention, and his family members were came to my office, and they also told me that nobody is there to appear. So I took his brief. I went to Mysore and filed wakalat with the aid and assistance of certain persons to because they were in those associations were also on grudge towards the person who appeared for this Fahad. This is the scenario. So that my advice is that there will be threats, challenges from different corners, and you will be committed to professional law. And you should keep morality, you should keep dignity, and you should be, then you will be on exalted position of the profession.
Thank you, Shareef Saab, on behalf of Inside Media team and the audience watching us. I thank you for your valuable time spared for this short interview, and we wish all our prayers and greetings to your fight for justice. Inshallah, we'll be in touch. Thank you for watching us on Inside Media. Stay tuned. We'll be back with more interviews similar to this. Assalamu alaikum.